So I'd like to say good morning, good afternoon, or good evening, depending on your time zone, and welcome to day 2 of the 11th Annual Cambridge International Law Conference. Ms. Maja Groff will be delivering a keynote speech this morning, and it is my pleasure to introduce your chair for this session. Dr. Markus Gehring is the director of the Center for European Legal Studies, fellow and director of studies in law at Hughes, and a fellow of the Lauderpack Center for International Law. Before joining the law faculty, he served for 2 years as tutor in sustainable development law. He was also a fellow in law at Robinson College from 2005 to 2012. He has been a visiting professor in several law faculties around the world and held a Jean Monnet Research Chair ad personam in sustainable development law at the University of Ottawa Law Faculty in Canada. And without further ado, here is Dr. Markus Gehring.
Thank you very much. I feel slightly humbled by that introduction. Welcome and good morning to so many of you who realized that the United Kingdom and many other countries around the world had a time change this morning. So special kudos to everyone. From a European law and international law perspective, I think any day of discussions about global governance couldn't be more timely. I think we are in the process of seeing real realignment of the way the world governs its own affairs. And for that reason, we shouldn't forget the events that are happening right this minute in Ukraine and in many other conflict-affected countries around the world. I think with the one positive element of the world witnessing the day-to-day suffering is that no one can claim innocence. No one can claim that they didn't know that there were severe challenges to international governance, to international law in particular. And it's in that context that I invite all conference participants to enjoy this full day, the second full day after the rich discussions that you had yesterday of the Cambridge Law Journal of International Law Conference 2022. It's also a particular pleasure for me to introduce our day 2 keynote speaker. Maja Groff is an international lawyer who has assisted in the development and servicing of multilateral treaties, also working at various international criminal tribunals and teaching regularly in the Hague Academy of International Law. She has worked on existing and potential global treaties addressing inter alia the rights of the child, issues disproportionately affecting women, persons with disabilities, access to key legal information, and many other topics. She's also acted as in her liaison work with international organizations, including UN bodies, with international professional associations, NGOs, and has played a key role in convening a wide range of international legal expert groups. She is a practicing lawyer. She's admitted to practice in the city of New York City and has served in the international law and UN committees of the New York City Bar Association. She's also the recipient of the 2018 New Shape Prize for Global Governance Innovation. What a splendid speaker to start us off on a discussion about the future shape of global governance. Maja, you've got the floor.
Wonderful. Thank you so much, Markus, for that kind introduction. And it's a pleasure to be here with all of you today, joining you from the Doha Forum in Qatar at the moment. So it's a pleasure that we can be together in this virtual world, and indeed, as Dr. Gehring said, at this very poignant time in our shared history. So firstly, I would like to commend the organizers of this event and the selection of the very important theme for the annual conference, strengthening global governance through international law, challenges and opportunities. And as was alluded to, as an international community, we are indeed currently faced by a range of difficult problems represented by the very concrete circumstances we can see on the ground and indeed daily see on the news. And I would say that the problem set that the international community is now facing is extraordinary, complex, and unprecedented for modern society. I'll say more in a moment about these interlinked challenges that we're facing. And in my view, it will very much test the limits of our problem-solving ability at multiple levels of governance. So we will without doubt have to develop new and refreshed perspectives and capabilities as an international community to grapple with the current challenges. And indeed, in this process, our global governance will have to be strengthened, I believe, and the role of international law is, of course, in my view, absolutely central to these efforts, and there is much to be done and much potential that we can all, as practitioners and academics, very much take hold of and contribute to. So I would just suggest that the theme of this conference highlights a vital issue of our times, indeed a defining issue of our times, both for our current generation, as Dr. Gehring was alluding to, we're at some kind of inflection point, and for the generations just to come. So very, very relevant for current young lawyers, legal practitioners, academics, and those who will come after. Before I will share some thoughts on what I see as some core challenges and opportunities for strengthening global governance and international law, specifically from my vantage point as a practitioner, I would just like to set the stage by indeed commenting on a few of the global risks that we are currently facing. So first, despite over 76 years of the existence of the UN Charter, we see and we have to acknowledge the backdrop of current events, which show how macro and hard security and geopolitical risks are still very much alive and have the potential to intensify and multiply further beyond the Ukraine crisis, beyond the other conflict zones we see around the world. But we've seen over the last months, these very dramatic events unfolding in Ukraine. And I have heard some commentators note that in terms of the possibility of a nuclear exchange in recent weeks, this is likely the most dangerous situation the international community has faced since the Cuban Missile Crisis. So that is a mutually assured destruction scenario is alive and well and threatens all of us. So we're seeing just how fragile and incomplete our current international security and global weapons governance and legal frameworks for weapons governance really are, and that they are not yet fit for purpose to prevent the dangers now confronted. Adding to this, of course, as I'm sure the younger generations are very acutely aware, are the interrelated global climate, biological diversity, and ecological crises, which represent a new kind of biophysical system security challenge for the international community. We are being told by leading scientists that the stability of the whole Earth system, which is the basis for current life on Earth and our societies as they've been flourishing for the past 10,000 years or so, this whole Earth system is under threat. A range of the Earth's scientifically defined planetary boundaries have already been overstepped. So these ecological challenges, which by their nature are both intensively local and also planetary, are unprecedented. And I often get the sense that the policymakers have not yet internalized the gravity of this very novel challenge with vast implications for the international community and its governance architecture. So just a few more facts and perspectives on the current climate challenge. A recent IPCC reports have shown that we have reached the warmest temperature on Earth in the last 100,000 years, and that we are now being hit by the consequences harder and more often than was earlier expected. Risks of irreversible changes and tipping points in the Earth system can no longer be excluded. And we've been told recently by leading scientists that 9 of the 12 big biophysical systems which manage the global climate are starting to show signs of instability, in some cases 50 to 100 years ahead of what the previous scientific models have predicted. So these are very complex, novel challenges. And even if we reach the 1.5 degrees Celsius temperature limitation target noted in the Paris Agreement, we are still very likely committing all future generations to at least 2 meters of sea level rise, which will have huge implications for the adaptation of our cities, communities, societies. So the risk of the consequences and our changing global landscape is very multifaceted. So I share some of this cross-disciplinary information also because law is an applied and practical discipline. It's also a social product, an instrument, and it's meant to solve shared problems. And in terms of the prevention of violence and facilitation of peace, one of my favorite quotes from jurist Hans Kelsen, he noted very aptly many years ago now that, quote, law is essentially an order for the promotion of peace. Thus, the need to strengthen international law is imperative if we are to assure a more durable international peace. And again, indeed, current circumstances show how fundamental the strengthening of the legal architecture is if we're going to ensure a durable peace. And given the nature of our shared problems, which are planetary in scale, in particular in relation to these current novel ecological crises, we have to, as scholars, practitioners, understand that we're now part of an international social community that's quite inevitable, for better, for worse. Our societies must also take on this very important international dimension. So I would suggest that all of this has consequences for international law, whose tools and resources are now needed much more than ever. But which we also have to refresh these resources and tools with new perspectives, progressive developments that are equal to the challenges that we face. And of course, in highlighting the geopolitical risks just now, the weapons of mass destruction, and these novel ecological crises, I'm leaving out a range of other crises, potentially existential problems, potentially issues of global systemic risk, for example, of course, current and future pandemics, which we know are potentially accelerated because of climate change. We have risks in the international financial architecture, ways to properly manage global financial risk, crises in international economic inequality, illicit financial flows, networks of tax havens, transnational corruption and crime. The Bulletin of Atomic Scientists has identified misinformation, what the Secretary General calls an infodemic, as a systemic international governance risk, unknown risks and consequences of the advances in artificial intelligence, among others. So this is what I mean when I say that we're facing a very challenging, but also very interesting problem set at the moment. So how is our international governance faring in the light of these challenges? What might be some signs or indications? So for example, if we take our apex international security and executive body, the UN Security Council, as we have seen in relation to the Ukraine situation, other very intransigent, very destructive conflicts, the Security Council is not only failing to address the hard security issues of large-scale interstate conflict, but also stalled in terms of meaningful statements or engagement with the climate and ecological security discussion. For the latter, of course, there are concerns that the Security Council as constituted is without appropriate mandate in this field, not fit for purpose for the complexity and whole of system sort of approach needed for climate and ecological risk. However, we lack an apex executive body that might, for example, declare a state of climate emergency on the planetary level, which scientists have told us this is scientifically valid and appropriate given the state of our Earth system. whereas the UN Secretary General, for example, has called for every state in the world to declare a state of climate emergency. And even before the Ukraine crisis, there were indeed warnings of the worsening of unstable rival superpower and regional power contestations, prognoses of geopolitical crises in rearmament, in multilateralism, from many prominent voices in the diplomatic and international civil service spheres. So just as we need our architecture the most, there's this sort of withdrawal or regression towards older patterns. So these backward geopolitical trends, what has been called commonly a threat to the rules-based order, comes in this epoch which the philosopher Toby Ord has christened the precipice, which I think is very appropriate. He notes that the global community is confronting indeed this acceleration of intersecting and potentially existential risks, some of which I've mentioned. And he notes, quote, "We see a species precariously close to self-destruction, with a future of immense promise hanging in the balance. Safeguarding humanity's future is a defining challenge of our time." So that's quite dramatic, and that's quite dramatic for us as international lawyers now, and the younger generations also, how we respond if we indeed are on this precipice. And the UN Secretary General, in his 2021 Our Common Agenda report, indeed, he notes that he feels that humanity is at a stark and urgent crossroads, and that the international community faces a test in international cooperation that will result in either breakdown or breakthrough, with its greatest shared challenge since World War II. However, again, times of crisis do present opportunities and often invite a return to earlier ideas and foundational principles. And one of these, I would argue, is the need for the international community to give much more serious and focused attention to the further progressive development of our core international institutional architecture. So with this in mind, two co-authors and I published a book in 2020, published by Cambridge University Press, with some key proposals to upgrade our essential international governance architecture. And this was before the pandemic broke out. This was before the Ukraine crisis, but already we had the feeling that this was an urgent upgrade. So the genesis of these proposals in the longer book was a short proposal submitted for a Swedish Foundation Prize, which called for the challenge of developing a new comprehensive global governance system to manage the range of global catastrophic risks that are confronting us. So we submitted a proposal that was subject to academic and expert review panels from all regions of the world, with 2,700 proposals from over 120 countries. And our proposals was one of those selected. So a key premise of what we suggested for the international community to take seriously and move forward with was that really to enhance our management of global catastrophic risk, we have to enhance the integrity of the entire international governance system. And a key focus, therefore, of such enhancements must be also on the UN Charter as the core preeminent international treaty regulating international affairs. And many of you may know or recall that it was agreed in San Francisco when the Charter was negotiated that there would be a revision conference within 10 years of Charter adoption. That promise is enshrined in Article 1093 of the Charter. And also you probably all are aware that the P5 veto issue was a sticking point in San Francisco and remains a key issue today, often raised and most commonly in terms of reform efforts. But this aspect also of the Charter, that it was meant to evolve and to be revised, and that the 1945 version was a first iteration, is largely lost in terms of our political memory. So a few of our proposals in our book, I'll just mention some of them in terms of what we think this institutional architectural upgrade should include. Firstly, an international rule of law package. The International Court of Justice has not been reformed in 76 plus years. Chapter 6 on peaceful settlement of disputes is susceptible also to being strengthened to ensure that it is featured as the cardinal principle of our international system. A judicial training institute, upgrade of the human rights architecture, its next progressive step, focusing on accountability, the establishment of an international anti-corruption court, which now is a proposal that is being championed by Canada, and other governments are now very seriously looking at this proposal as international corruption poses a systemic global governance risk. We also talk about how we might be able to further and make good on the promises in the Charter under Article 26 and Article 43, which were tasks of the Security Council first to develop a systemic plan, a plan to share with the whole of the United Nations on the systemic governance of armaments, regulation of armaments disarmament, which was never followed through on, and Article 43, of course, on security arrangements between member states, collaboration in order to ensure effective collective security action. And just a note from my international treaty practice, it's very common in international treaties, especially of a particular vintage, for states and member states to forget certain provisions in the treaties or them to be sort of not actualized, and it's more a process of forgetting, and there need to be reminders and urging and serious work to make sure that the various features of this charter system are actually actualized. We also propose that the legislative capacity of the UN is enhanced with a transitional World Parliamentary Assembly body, advisory at first, that could drive a more people-centered and vibrant discourse at the UN. And also in terms of its legislative capacity, how do we move to more effectively, legitimately, and quickly updating, adapting international law so that it can evolve also more quickly in step with the challenges confronting us. We also propose a more reliable and enhanced funding mechanism for the UN. One of the common complaints about international courts and tribunals is that they're very expensive. They're not expensive compared to many other expenditures, including on military and defense. And indeed, there are much more rational, reliable ways to fund UN and related operations. And we have proposals in that respect. And finally, I'll just mention one last proposal. There are many in the book. The UN Security Council, we suggest, should be transformed to an executive council without the veto, and that there is a system implemented of weighted votes based on a rationalized formula to be reviewed regularly. And the executive council would have 24 seats, 6 dedicated to US, China, India, EU, Russia, and the rest of the seats would be regional with rotating representation. So everybody is essentially represented on this executive council. But just to note, again, our intention in these proposals for the Security Council would be that it become a body that is depoliticized, that is fair, that is functional, and that is in line with current norms of governance legitimacy, and that have rule of law principles at their heart. So this is just a sketch of the few proposals we made, but really it was intended to be our reasonable efforts at suggesting the next logical steps to increase the overall governance capacity of the international community, not because we thought those reforms were politically feasible at the time or now, but we feel that upgrades of this sort will likely simply become necessary at a certain juncture based on our global circumstances. And then indeed, you see some of those tensions and crises intensifying already. We also felt that fresh ideas and discussion are very badly needed. and that there should be open discussion about where we are headed as a global community and whether our core global governance architecture is really up to the task. And indeed, you do see shifts now, which are quite promising in response to the Ukraine crisis. The procedural referral from the Security Council to the General Assembly, the proposal from Liechtenstein that's leading an effort with other mid-sized, smaller countries to request that anytime there is a veto in the Security Council, the matter should be referred to the General Assembly, that there should be reasons given by the permanent member that has applied the veto. And then again, renewed calls for Security Council reform. To quote one Ukrainian American academic, in the 20th century, when people talked about reforming the UN, it was an academic exercise. Today, changes are simply unavoidable. We are at the point of no return. So indeed, it will be interesting to see if the international community really does come up with fresh perspectives on how it wishes to move forward around shared norms. And also, very strikingly, the current Ukraine situation, the recourse, which has been swift and very strong to international justice institutions and mechanisms, has been quite dramatic and very, very encouraging. So as you all may know, the ICC, of course, has very rapidly opened an investigation with an unprecedented number of member states referring the situation to the court. At the same time, there's the successful petitioning of the International Court of Justice, the Human Rights Council establishing a commission of inquiry, the proposal from the UK Prime Minister and others for the ad hoc mechanism trying the crime of aggression, and alternative proposals for an agreement between the UN and Ukraine to establish a mechanism to try the crime of aggression. So this is quite extraordinary about the broad range of avenues and the swiftness and the steadiness of the majority of international states and actors to flee really to this international justice system as we have it, as constituted. And in the past, too often international law has been treated as an incidental consideration and a subordinate, less serious force in international affairs. But this rapid and broad recourse shows how vital international law and legal institutions are to international politics. So international law should naturally have an absolutely privileged place in the solutions we find to our challenges. So they also illuminate again how important this potential reform agenda is. How do we strengthen this architecture further in service of the common global interest and as part of long-term preventative measures? So just to round out my remarks today, I would like to share, building on the above, a few observations from my international legal practice and what I see as possible fertile opportunities and fresh perspectives on international law, which might help to catalyze us progressively forward. And many of my observations are quite sociological in nature. They are about the way we practice international law and conduct academic research, which in my view are very important to consider to lay sound foundations for technical analyses, initiatives, and the concrete institutional reforms which I think are needed. So just to share a few perspectives in case helpful. Firstly, I've been really struck by, in my experience, there's still a dearth of practice opportunities for younger generations and for the international legal talent from all regions of the world, from all countries. There's an excess of international legal talent that is ready and willing to serve the international community. But our key institutions have not yet, they've progressed, but they have not yet adequately evolved to offer the sufficient opportunities that I think the current legal talent is ready for. So there needs to be more education of policymakers and of the general public also to be made aware of the need for strengthening international legal and governance institutions to serve the global public interest and indeed the interest of every country. Secondly, I think it's important to build international communities of practice and mutual support within our academic and practice communities versus cultures involving prestige contests, which is sort of an old school way of doing international law or academics, because also these prestige contests are unfortunately mirrored at the international level. So how can we as a community of practice support new paradigms? How do we shift cultures in international legal academia and in practice to be more highly collaborative, which will enable the best substantive results? Also, we need to rethink notions of empire and related notions such as superpower or great power identities, which have formed a historical backdrop to international law, but which now seem very defunct, antiquated, and unhelpful given modern values and current challenges. So what are the new foundational concepts for the use of international power and capacity, rather than a traditional focus on adversarial contests? And how would international law adapt to these adjusted foundational concepts? Fourth, how do we cultivate a vision as international lawyers and legal scholars that is more bold and long-term, meeting the importance of our current collective moment while still maintaining a historical rootedness and also technical excellence? I see former heads of state and ministers and very capable judges, for example, with authority and experience,
Oh, I'm fearing we have a connection issue. I'm very sure the speaker will reappear in just a minute. In the meantime, could I invite the audience to pose their questions in the Q&A button that we will that we have opened up for the audience. Looking to the team, can we touch base with our speaker? I don't want to interrupt the keynote, but there was so much food for thought in what Maja Groff had to say about global governance, also about the history of the United Nations. Of course, as director of the European, the Center for European Legal Studies, I sometimes feel that you know, part of my research is aimed at one of those new emerging superpowers, right? Wouldn't it be nice to have a block of 27 sovereign states be regarded as a new force in international governance? But that was one of the questions I was going to pose. We are reconnecting with Doha, and we already have some questions. Could I strongly recommend that you also include your name and affiliation in your question, because that allows us to place the question and the context much better. Maja, you're back. Thank you very much. So please go ahead.
Thank you. Yeah, apologies. The internet is unstable at this venue, apparently. Yes, so just to conclude on my few perspectives from practice. So how can we as international lawyers very consciously focus more on techniques of diffusion, implementation, and enforcement of international law with concrete effect and with sufficient institutional support as needed, rather than too often being satisfied with disembodied international norms, which unfortunately is too often a trend in common practice. Also, how do we better forge connections between legal academia and international policymaking? I had some interesting recent conversations with an international lawyer who's worked for many, many years on very key global climate and environmental agreements for a major nation. And she was noting that she finds very little policy support in legal academic writing at the moment. And she wishes that somehow the wonderful academic thinking and writing could be made more digestible for policymakers and those who are on the ground, who are negotiating, who are implementing, and who are really in the field trying to use the tools of international law to address our contemporary problems. And lastly, just a point about potential synergies and collaboration with global civil society and so-called smart coalitions of civil society platforms and like-minded states. As international lawyers, practitioners, academics, we have to acknowledge that some of the major drivers of international legal change in terms of the architecture, for example, the International Criminal Court, the Landmines Treaty, some of these huge institutional reforms have been driven by lay people and civil society networks. So how can we interact better, support better these types of civil society platforms that are indeed really engaged with the policymakers, with like-minded states and diplomats? How can we support them and also like-minded governments and diplomats who are really committed to the progressive development of international law? My impression and my experience is that there are many diplomats at the moment who realize the gravity of our circumstances, but they need support with technical expertise, with international legal perspectives that are practical, workable, that they can rely on in order to really take forward their ideas and good intentions. So to conclude, I would like to conclude with a call to service, as our craft of international law is needed now more than ever. And one legal historical figure who I happened upon recently and who I find very inspiring is Green Hackworth, who was involved. He was a US legal practitioner. He was involved in the Dumbarton Oaks negotiations and then San Francisco meetings as part of the US delegation. And in particular, he helped with the drafting of the UN Charter, the statute of the ICJ. And he's described in his New York Times obituary of 1973 as a, quote, quiet, diligent jurist. He was, in fact, the longest serving legal advisor to the US State Department as of his retirement, assisting as the legal advisor for 15 years during a time of monumental and unprecedented shifts in international legal and political relations from 1925 to 1946. So to end, I would just like to quote from an address he gave in 1945. He was speaking to a legal society in his own country, but his words still ring very true to me today and are applicable to all of us. So he notes, the lawyers of this and other countries, no less than other seriously minded people, have a responsibility as well as an opportunity in this most important movement for the advancement of law and order in the international field. The maintenance of law and order among nations must not be pursued with less vigilance than the maintenance of law and order within nations if peace is to be assured. So to me, it's clear that this burden of responsibility he speaks about of the legal profession and indeed all seriously minded people has not yet been discharged. So I hope that we all may be quiet and diligent jurists, but also very much engaged with the issues of our time. So thank you very much. I'll end there.
Thank you so much, Maja. That was a splendid keynote and a very passionate call to action for more globally minded lawyers around the world. We have fantastic questions from our audience that I'd like to start with. George Darlington Hashaka, who's the chairman of the Uganda Peace Foundation, asks, what is your opinion about the need for drawing up a global pact on the environment, or indeed an international pandemic treaty to governance reform steps, perhaps? But what is your take on this?
Yes, absolutely. I've been in touch with some of the lawyers and advocates working on the Global Pact for the Environment. And unfortunately, that has been stalled at the multilateral process. But indeed, it was a very common sense and thoughtful and very helpful proposal to have a new global pact sort of treaty to connect the dots between different environmental obligations and fill in gaps. But I think, again, here in this situation, you see the problem of the theory and the practice and excellent proposals, and then getting the political will and getting the engines to drive the change and really to get the uptake strategically in the international community. So very much supportive of the Global Pact for the Environment efforts. Also, yeah, there has to be sort of a political strategy in terms of ensuring that these sorts of innovations have momentum and keep their momentum. But I don't think that the Global Pact for the Environment is adequate, is enough to address our global climate and environmental challenges. I think it's part of a package of needed reforms. So I'm very, very supportive, but I'm also thinking with different colleagues, interlocutors, about how we might propose more of a package kind of architectural and legal set of improvements for the international community. We've also had several former heads of state from Canada, from Australia, for example, proposing that we need a new IMF-like body to govern the climate. Right, and given the gravity of circumstances, this obviously is what might be needed. So I think the international community has to do very serious thinking on a whole set of global architectural reforms for the planetary environment and climate. Global Pact ideas should be part of that. And yes, for the international pandemic treaty, absolutely, it's clear that the measures that were put in place as a response to last pandemics were not adequate for the current circumstance. We've seen the costs to the international community, the suffering. So absolutely, this architecture has to be structured, restructured and rethought and buttressed. But again, in both areas, one finds the pushback of political actors and sort of the usual suspects also, often in terms of those who are hesitant for stronger international cooperative mechanisms.
Yes, excellent. And related to this is perhaps the question on the IMF and the Bretton Woods institutions. So someone asks online, what are your views on proposals to reform the Bretton Woods institutions and other multilateral development banks? What should be the direction of their reform?
Yes, yeah, I mean, obviously there's a whole host of issues that would have to be addressed in terms of like a new Bretton Woods sort of conference to rethink the global financial development institution architecture, which my colleagues and I would very much agree that is needed. And there's been a lot of learning There's been, of course, a lot of issues around political power and very difficult north-south dynamics, et cetera, different models of development. And so there's a whole set of multifaceted issues that should be taken into account. And my colleague, Augusto Lopez Claros, would very much agree that there needs to be both strengthening of these institutions in terms of their core capacities, to manage global financial risk, but also in terms of like the normative, the inclusive, the sort of also the justice perspective, and also sort of the policy lenses. At the UN at the moment, we have this very, very interesting discussion also mentioned in the UN Secretary General's Our Common Agenda report about GDP plus indicators. And within those policy circles, this is now very much embraced. We must move beyond our current indicators, given aspirations for a well-being economy, to manage our global environmental problems. But this has not yet sort of been embraced centrally in the specialized agencies for international finance and development. So there's also those sorts of normative shifts which should be integrated in my view. But again, it's very tricky without another very big calamity. The international community tends to be quite reactive, reacting to crises rather than proactively thinking, okay, how can we fine tune these institutions? How can we take the next progressive step to make sure they have caught up to where we are now, let alone our future risks. And just one more point in terms of our global financial and development architecture. One proposal we had in our book was also for an agency to tackle global economic inequality, which we know is a systemic risk with all sorts of dimensions, actually, and it's a very difficult social problem. It's a huge barrier to achieving the SDGs and just to have healthy democracies functioning, et cetera. So that could be part of a mandate of refreshed international financial and economic institutions, for example.
Yeah, brilliant. I was going to ask about the SDGs, which is sort of my area of interest. But we have two brilliant questions from our audience that I want to summarize and ask together. So one of our attendees thanks you for your keynote address, but then says there's just a dearth of opportunities in international law. So what would be some of the tangible steps that international organization could take to involve new talent? And related to that is a question from one of our hosts. Jean Quinn asks, thanks you for a great presentation, and then says, as a student in international law, she was curious about what you would view as the gaps between the current legal education and the practices in international law. So to questions about that community of practice that so urgently needs new members.
Yeah, very, very great practical and really important questions. So yes, unfortunately, I think in terms of creating these new opportunities, part of our role, I think, has to be a bit educational and also serving as advocates of the importance of international law, and indeed, as I mentioned, trying to speak with policymakers and even the general public to create our own opportunities. Unfortunately, I think that's part of where we're at presently, because I do think there's so much young talent that is really ready and willing to work, but not yet so many opportunities. However, there are some opportunities, and especially if one is creative and thinks sort of in a sort of strategic way in terms of working with NGOs, working with governmental authorities on international issues, and not necessarily having to, areas that are adjacent to legal practice, working on policy issues which are incredibly important, and a legal training is extremely useful in that respect. But I think one of the proposals I mentioned that we make in our book is a new funding mechanism for the UN, and this is a very unglamorous sort of topic, right? Most younger international lawyers would not take this up, or civil society advocates even have this as a passionate advocacy point. But I think this is really core. We need a more rationalized, stable, and enhanced funding mechanism for the UN and adjacent institutions, which could be done quite easily. Like the proposal that we have is a certain percentage of VAT, which is roughly, based on what the EU is doing. So it's just a stable, regular approach, which would help immensely. I'm also finding in sort of the international foundation philanthropy world, there's a growing awareness of the importance of international governance, of international law. So there's also funding, I think, in that realm for young legal talent to work with NGOs to raise funding for very important projects. I think there will be more and more appetite for good proposals with sound technical foundations. And then on the gaps between legal education and practice, it really depends, on the country. It depends on the university. There are really diverse programs in the world on international law. I feel fortunate to get my legal education at McGill University with a dual civil and common law degree, and with quite a number of legal practitioners there who could really connect the theory and practice. Also on the international front, a lot of international legal practitioners. So I think law faculties have to really cultivate this awareness, and the students should also request and ask for this kind of exposure. And what I also recommend to young lawyers and academics is really to keep conversations open, to keep talking to practitioners in your fields of interest, because usually practitioners are more than willing to converse and share experiences. And this will get you extremely valuable information and insight, because we do indeed have a rich international legal practice already. It's just sometimes difficult to connect. You need a bit of persistence and effort to connect with the various fields of practice.
Yeah, we have perhaps time for just one more question, and apologies to everyone else who has asked a question, but there's a question about what you think about transnational corporations, considering their significant effects on environmental issues. How do they fit into the mesh of global governance? And I fear that's probably the last question you can ask after this, we can ask after this wonderful keynote.
Thank you. Excellent. Another excellent question, and also very practical and really important. And I've been wanting actually to write just a short piece for some time on, how do we think about transnational corporations as, global governance actors in themselves, as, many transnational corporations have much greater resources than many countries of the world. This is a reality. So in this, there is both, risk and danger, of course, but also there's great potential. I very much agree in greater international regulation, not just, soft law and non-binding norms, but much stronger international law and international cooperation on making sure there are, key obligations of transnational corporations around the world. There's a level playing field. This effort for a global minimum corporate tax is extremely positive step forward that happened just recently but there's many other issues that need very focused attention. But I just want to say also, I think there's also some very positive potential there. I think I've been involved in the B Corp movement, benefit corporations, and some very large ones that really want to take seriously their obligations to society, to all stakeholders, to the environment, and also younger generations. People want to work with these corporations. There is a flight of talent also to the companies that are really walking their talk. So, and we see this in the Ukraine situation, you know, look at IKEA, what IKEA has done. So there's incredible sort of potential there for the sort of business space also to be a responsible, positive actor in our international governance mix.
Thank you very much, Maja. I had many more questions as someone who studies the European Union. So many ideas that you sort of highlighted for global governance, I think had a bit of a petri dish experiment in the European Union. But I don't want to sort of prolong this session. We thank you as the Cambridge, very practical, I might add, international law community for your wonderful keynote to this conference. And on behalf of the Cambridge Journal of International Law, and all my colleagues in the Faculty of Law, I thank you very much for your contribution this morning.
Thank you so much. Lovely to be with you.
Thank you. And that ends this first keynote. Can I invite all the participants to please join the very interesting panels on international governance that will follow this day 2 keynote. And then there's another keynote later on today. So thank you to the organizers. I hand back the chair to the organizers.